Now, looking at the case valuation side of things, can
Hmm?
you walk us through the tiered valuation of these cases? What does that
Sure.
mean from an advertising standpoint and take standpoint?
No problem. So it's our firm, Anna Paul Weiss, and a couple other firms have gone together, and no one says they have to abide by this, but this is what we're basically doing, the
Right.
working
So
group of
you
lawyers who work on
specifically
these cases. And this is how we're looking at grouping and classifying the cases as they come in. So we look at a tier one case as a case where the perpetrator met up with the child.
in
So
person, like face to
in
face.
person, generally physical sexual abuse, and it's the worst of the worst. And it's hard to put a value, and nor do I want to put a specific value on a case because it's way too early. But those are cases that typically, if they're standalone and not part of an aggregate in terms of, you're trying to settle a mass group of cases, these are cases standalone value would be over $1.52 million dollars all day, every day, even the most conservative of venues. So these are cases that one could, if you were looking at it, and I hate to, it sounds almost strange, a little bit cavalier to put a financial value and be discussing this regarding sexual abuse cases. But putting that aside for a second, hope no one judge me. Those are cases that we put a conservative value of at least $750,000 on. I'd be shocked if those cases settle for less than that. A tier two case is the child shared what's known as child sexual abuse materials. These are explicit photos of the children they shared with the adult perpetrator. Those cases, I mean, want to be very conservative. I would say that they have a value over $250,000, over 250. A tier three cases where the adult shared explicit images with the child after grooming. So I want to be clear, a tier two, tier three, this is after there was ongoing grooming, and then which is a pattern of behavior where you're establishing a relationship with a minor child with a sexual intent. Um, the tier three cases we're putting conservative value of about $100,000 on. Probably worth more, but who knows? And again, it's very strange to discuss these values, especially so early. In a tier four case, that's just pure grooming. And we have to be very careful here. And I'm going to go into it, when as you go further into this discussion, that's where you're going to see the most fallout. And that's where you got to be very careful of what cases you're taking. And we will not take a tier four grooming case without having a documented behavioral incident or ongoing therapy where this was discussed with the therapist. You want like some kind of demarcation point where you're not relying on mom and dad giving you an anecdotal statement that Johnny is not the same as Johnny used to be. Johnny's withdrawn, he's angry, he's sullen. That's not going to fly. It's going to be very difficult to get that past judicial scrutiny, let alone defense. Um, we want to see behavioral issue. We want to see a documented therapy. And then tier five, and these aren't in sequential order because tier five is actually as bad as tier two and tier one cases. This is there was sexual grooming, and then it resulted in suicidal attempt, actual suicide. We have a few of those, and it's horrific. Or self mutilation by the child.
Wow.
Yeah, I mean these aren't for the faint of heart. These are some horrific cases.
Now, let me just ask you, do you ever find yourself getting emotionally invested in these cases?
I sure do. Hmm.
I can't
It's home. I
imagine.
have four children. Um, yeah, these are not. It's tough, especially when you're dealing with the parents who blame themselves for what occurred when it's not their fault. They relied on misrepresentations, statements from a publicly traded company that their product was safe for children six and above.
It's heartbreaking,
It
honestly.
is.
No,
Hmm.
let's talk timeline. Given the severity of these allegations, what kind of pressure, if any, do you think Roblox faces to resolve these cases?
When you ask about timeline, we can go through the pressures, but timeline's tough to say because it's so early and this is such a nascent litigation. It's brand new and discovery is only just beginning. But and also some of it's stalled out right now while we wait for the JPML to have a ruling, and where the oral arguments will be in December 4th, the hearing.
December.
Um, I think this is going to be a much quicker timeline than your traditional mass tort one because it's not expert Latin, science Latin, but more specifically, they're going to face the same pressures. And we saw something similar in the Uber rideshare litigation, which I'm not a part of, but I have some good friends that were on the steering committee that are leading that litigation. And what we saw there is that the public pressure forced Uber to do away with the arbitration provision, arguing that arbitration was the form. which you're doing in this case. And we believe that that may cause Roblox to do the same thing here. But who knows? We don't control their behavior or conduct. They may still try to force arbitration down the throats of minor sexual abuse victims. Think about that. And we have many arguments of why arbitration should not apply. And I can get into that in a few minutes, but notwithstanding the fact that there's basically two threshold issues, arbitration and Section 230. I think once those are ferreted out, and they'll be ferreted out within the first year, there's not much else that Roblox can be able to defend these cases on. It just gets worse and worse for them the further we get into discovery. So do I think this will come to a swift resolution within a year and a half, 2 years? I do, but is there any guarantee of that? Absolutely not. Other mass torts, I hate to compare it to a science lab mass tort, but you look at like talc. Talc's like the never ending story. They're on year 10, 11, 12 of that case. So these cases sometimes drag on in perpetuity. I don't think we're going to see that with Roblox, though. I think there's going to be enough pressure on them, and their case is just so weak.
Yeah.
Outside of arbitration and trying to argue that this falls within 230 when we're arguing this is a design defect case, I think they're going to fail on both, and they're going to fail miserably on both.
I hope it wraps up
Yeah,
quickly.
as do
Until
I.